Welcome. I'm Michael Paris. I teach in the political science department. I'm also the pre-law advisor for the college. So if that's something interesting to you, you want to find me and talk to me. I'm going to start. I mean, some people will be filtering in for the next 5 minutes, I would imagine, and that's just fine. We're delighted to have Michelle Adams, a law professor, the Henry M. Butzel Professor of Law at the University of Michigan Law School. If you don't know, Michigan Law School is a top 5 law school in the country. She's written this wonderful book that we'll be talking about in a few minutes, The Containment. And before we begin, we'll find out more about our guest, our distinguished guest, when we sit down and talk with each other and have a little conversation about this book. I want to just do a little preliminary overview of what we do in legal studies and pre-law advising here. It's a little awkward here, I'm sorry. I'm usually doing this. So this URL is, if you go to this site, csilsi.com, law and related fields and your resources and opportunities there, you will get that in your inbox. We're here to help students and grads negotiate the legal field and related fields. We offer resources and opportunities in law and related fields, and we also want to enhance the intellectual environment here at the college, and the events like this one contribute to that. We want to give everyone a fair shot at the American dream. That's our mission at the college, and this is our little piece of it with law. So we have a minor in legal studies. I do one-on-one pre-law advising with anyone who wants it, whenever and wherever you are in your career. It's never too early to talk about it and think about it if you might be interested in it. We run workshops for students throughout the year, LSAT prep, law school admissions process, and careers in the law panels. We have public lectures. We have internship placements. My dear colleague Rich Flanagan is here from the political science department. He runs some internships courses. You can get course credits for internships, and many of those are in legal settings. And we also have a new funded summer internship program funded by our friends at the Scamardella law firm. Bob Scamardella is a graduate of CSI, class of 1972, Brooklyn Law School, class of 1975, and his firm, Staten Island firm, provides some money for this fund, and part of what it does is fund summer internships, and part of what it does is give you a voucher for $500 toward your costs for law school applications or LSAT prep or whatever is related to law school. We also have an endowment in the name of Dan Kramer, who taught here for 40 years. Mr. Kramer had a JD from Harvard and a PhD in politics from Penn. And his surviving spouse, Rashenda Kramer, has been very generous. We're working on a new student lounge in 2N that's under construction, funded by this endowment. Ms. Kramer was going to be here. She couldn't make it in the end. And in terms of this event, I want to thank the Pre-Law Club, the Student Government Association, Dave Pizzuto, who does the media and the recording, Carolyn Gianola and Auxiliary Services will be putting up a reception. So when we're done here, about 5:45 or 6, there'll be a nice array of food and drink upstairs. I hope you'll join us to continue the conversation. Joe Cipoletti does the tech support here, and he and his friends have helped with this. And I want to thank Dana Trimboli and Cheryl Edoff at the CSI Foundation for support. Okay. On October 29th, join us. We're going to do this again. We're going to talk about academic freedom with a great scholar on the subject, David Raban of UT Austin Law School. Same sort of setup. So mark your calendars for that. And, I'd like to say, you see that little logo up there by the College of Staten Island, right? It's a little circle with some lines through it. It's a nice logo. The lines represent a span of the Verrazano Bridge, and the circle is a symbol of community. So I'd like to say we have a community. We try to foster good relationships in this academic community. And we try to build bridges for people to get to where they want to go, to succeed as they themselves define success. So I want to just run through a little of our success stories, our student success stories, for just a minute before we begin. This is Justin Giles. I met him in 2010. He looked like that when I met him. And he had a great career at Fordham Law School. He clerked for the 11th Circuit Court of Appeals. He wasn't an honors student when I met him. He wasn't Macaulay or Verrazano. He was just kind of a genius, and he didn't know it. And that's him about 7 or 8 years ago. It's quite a transformation. I don't know about you. I might want to have dinner with the first kid, not the second kid. I'm not sure, but he's very happy with his career. Alex Deutsch went to Cardozo, where Professor Adams taught for many, many years, very successful in corporate practice. He made law review at Cardozo. Jenna Jankowski, another honor student, went to Drexel. Drexel's a great place. People don't know that much about Drexel, but they have a kind of a co-op approach. They have people work while they're in school. And Jenna's had a career in public service. Naomi Edwards, Brooklyn Law School. As a legal services lawyer, advocates to alleviate the pain and suffering of people victimized by domestic violence. And this is her area of specialization. So in the last 4 years, we've had 13 students go to law school on full tuition scholarships. These 5 all went to New York Law on full scholarships, no tuition. 3 of these 5 went to law school on full rides the next year. All 3 of these students, 1 at Seton Hall, 2 at New York Law, full tuition scholarships the next year. Starting law school now, 2 of these 6 students are on full tuition scholarships right now. Okay, so I'm going to go back here. Welcome, everyone. I know some of you just came in. I'm not sure why we're tilted over there, but it's fine. We'll try to face you when we're talking, I guess. And again, we are absolutely delighted to have Professor Michelle Adams here to talk about her recent book, The Containment, Detroit, the Supreme Court, and the Battle for Racial Justice in the North. Please join me in providing a warm welcome to Professor Michelle Adams. Okay, is this working? Is this working? You want to test your mic? So nice of you to do this.
This is great.
Is it working? It's working.
Sure is.
Wonderful. So thank you so much for joining us. Michelle Adams is a really accomplished legal scholar. She's published in Yale Law Journal, many other major law reviews, a long career in the legal academy. I'm going to forego the long introduction because we're going to talk about her background and her career a little bit. Somebody want to check their phone? Okay. And not talk on it while we're having a program, perhaps? Perhaps? Okay. So, thank you for doing this. Really appreciate it.
It's my pleasure.
This is a marvelous book. It's deeply researched. Any and all sources, media sources, private correspondence, trial records, published research, it's all mobilized to create a beautiful narrative about this case and this conflict that is a bit hidden from history. The great historian E.H. Carr once said, before you know the history, know about the historian. And I learned on the car ride here that Professor Adams was a history major as an undergraduate at Brown, so that's not surprising. This is a beautiful work in history. Tell us about yourself.
Well, first of all, thank you so much, Michael, for having me. This is wonderful, and thank you for coming out and spending some time talking about my book and just getting to know each other. So what do you want to know?
I want to know where you were born, what schools you went to, and a little bit about your legal career in 20 seconds or less.
Okay, 20 seconds or less. I'm from Detroit, Michigan.
I'm kidding.
Yeah. I'm from Detroit, Michigan, and I grew up there until I went to college. As Michael mentioned, I went to Brown, where I majored in history, and I love that, and I love reading everything that has to do with history of many, many different kinds. My father was a lawyer, and my godmother was a judge, and growing up, I wanted to be just like both of them. And so I went to law school, and I went to CUNY. I graduated in 1989.
Wait, that deserves a round of applause, because CUNY Law School is a real gem of a school, vital locally and nationally, I think. So.
Yes, it is. And it was a great experience for me because it was just an opportunity to really spread my wings and also to get to know the professors there and to get to know my classmates. And it was designed, as you all know, to really sort of feed students into public interest law, and I knew that's what I wanted to do. I clerked for a year with the federal magistrate judge, and then I went directly to the Legal Aid Society. And I worked there for 3 years. I worked on a big case against the New York City Housing Authority. But one day I saw one of my colleagues at a typewriter. I said, "What are you doing?" He said, "I'm applying to be a law professor." I said, "Oh, I didn't know you could do that." And at the time, Harvard had a new program that was intended to get more folks of color into law teaching. I applied for it and I got it, and I guess I should have known that I would be the kind of person who'd want to be a law professor because I wanted to have a 4th year of law school, and most people don't want to do that. So I went there, and then after I left that program, I started my teaching career in 1995.
Wonderful, thank you. Could folks silence their cell phones, please? I appreciate it. So this book is just out about a year and a half, yes?
January.
January, yes. Why did you decide to write this book? Law professors usually make their career and get ahead writing law review articles, and you've written quite a few. But it's not so common for a book, a narrative history. How did you come to write this book, and why is it titled The Containment?
Yeah. So I don't know if any of you have had this experience of just having something that you just couldn't let go of, that you just kept thinking about something over and over and over again, and you just wanted to explore it more and more and more. And that's really what happened with me in a case called Milliken versus Bradley, which I'm going to talk to you about, which was decided in 1974. And that's a case that I've taught to students over the years in the different classes that I teach at law school. But it's not a case that's one of the big hitters in constitutional law class, in law school. You guys have all heard about Brown versus Board of Education, and so we spend a lot of time on that. But I kept thinking that this case was almost as important as Brown, maybe even just as important as Brown versus Board of Education. And so as I read more and more and more about it, I kept wanting to read more and more and more about it. And at some point I realized there was an incredible story that was buried in history that hadn't really been told. And one of the things I wanted to give myself an opportunity to do was to write a book that not only spoke to law students and law professors and political scientists, but spoke to general interest audiences who read nonfiction, folks maybe who haven't thought that much about the Constitution but are interested in the world around us. I wanted to write a book that was a story of a really important case, but that was done in a way that was accessible to everyone, but that didn't dumb any of it down. I wanted to invite you all into my law classroom, and I hope that I've been able to do that. And so that's really what got me started wanting to write this book. Now, you also ask, what's the containment? And of course, you see that that's the title of the book. We'll talk more about this, but the containment, there's a trial that leads up to the case that goes to the Supreme Court. And in the trial, the lawyers talk about this concept of the containment. And really what it was the idea of a movable ghetto, right? The containment was sort of the explanation or the reason why, when you looked at a map of the city of Detroit, and you looked at it in 1940 and then 1950 and 1960 and 1970, why it was that African Americans were clumped in sort of the center city, and then maybe 10 years later a little bit further, 10 years later a little bit further than that. And so one of the things the lawyers do in the case is they break down why it was that black folks were contained in those particular neighborhoods, and then within those neighborhoods in particular schools.
Right, thank you. And that kind of leads to my next point. So if I say that scholars have talked about, in the last 20 years, the myth of Southern exceptionalism, what does that mean to you? And this book is kind of about that, right?
Yeah. So the myth of Southern exceptionalism, there have been a bunch of folks who've written about the idea that when we close our eyes and we think about Jim Crow, we think about a whites-only drinking fountain, right? And we think about the South, and we think about Bull Connor and all these kinds of things. And I think there were a number of scholars who talked about the myth of Southern exceptionalism, and basically what they were saying was, actually we had a nationwide policy of Jim Crow, but it had different regional variations. And so one variation we're quite familiar with. It's sort of, seared into our brains in terms of thinking about the drinking fountains. But there was a northern and a western regional variation. And it's the northern variation that I write about in my book called The Containment.
Yes, okay, thank you. So we need to talk about a few little background things before we get to the story of Milliken v. Bradley and the people involved in it.
Sure.
So probably not everyone is terribly familiar with Brown 1 and 2. In the beginning there was Brown is iconic. I think the point to maybe note here is that it was also kind of opaque, right? That it could be read in many different ways. Many people could do different things with it or see different things in it.
Yeah.
One other scholar called it a Rorschach test. Like you lots of ways of looking at Brown. So maybe just talk about that a little bit and how that plays into your story.
Sure. How many folks here have read Brown versus Board of Education? At some point or another, right? Or pieces of it.
Faculty members should just keep your hands down, okay?
So one of the things that's really interesting about Brown versus Board of Education, if you sit and you read Brown versus most of the cases that come out of the Supreme Court today, is the very first thing you're going to notice about it is that Brown is really short. Today, particularly with word processing, the cases are very, very long, and they're often very complicated because it's hard to figure out even what the court said, because you're going to have a majority opinion, and maybe you have a plurality opinion, and then you have two concurring opinions, and then you have three dissents. And you've got, one of the things that we train lawyers to do is to figure out how to put all those things together and figure out what was it the court actually said. Brown's really different because in Brown, you had a court that was unanimous, and it was writing for public consumption. Today, the Supreme Court writes largely for specialized audiences. I think they don't write to Americans, and I wish that they did that more. But Brown was written to be published in the newspaper. And so it's very short, it's very clear, in the sense that it's relatively easy to understand, but it's also a Rorschach test. So what Brown holds, which I think we all know, whether we've read it recently or whether we read it 10 or 15 years ago, is that state-mandated school segregation is unconstitutional, right? Violated the Equal Protection Clause of the 14th Amendment. And so Brown says, states, you may not do that anymore. It doesn't say any more than that. It doesn't say, what do states have to do if they've been maintaining a dual school system? It doesn't tell the federal courts how to actually deal with the school officials. It just says, this is unconstitutional. The reason why Brown is a Rorschach test is because it's not clear why it's unconstitutional. It's one thing to say that the states that are requiring this by law are violating the law, but the question is why, right? And so there's a bunch of different reasons why that might be the case. One reason might be that in the laws that required students to go to separate schools, there were racial classification schemes. So the law said white students must attend white schools and black students must attend black schools. And so it was the racial classification schemes in the state laws themselves that actually violated notions of equality. That's one reading of Brown, and that's certainly a very reasonable reading of Brown. But then there's another reading, and another reading says, well, maybe it wasn't just the fact that students were being separated on the basis of race, but there was something behind the desire to separate. And the thing behind the desire to separate is that we're creating a system of folks who are on top and folks who are on bottom, right? We're creating what's known as a caste system. And so when the government creates a caste system, when it basically decides there's going to be a system of racial superiority and racial inferiority, it's that thing that violates the Equal Protection Clause. And this reading matters because, for instance, it might change your views on whether you think something like affirmative action is constitutional. It might change your views on how far the state has to go to actually heal what it had been doing in the past. So there's all these different ways that you can read Brown versus Board of Education. And the fact that Brown was a Rorschach test, the fact that Brown was a bit of an enigma, ended up meaning that it was hard for the states and hard for lower courts to be able to figure out exactly how to enforce it.
Yes, and the book, it's kind of hidden from history that even knowledgeable scholars will say, well, in the late 60s, Brown moved north because the Supreme Court addressed school segregation in the non-South then. But Professor Adams shows that Brown was there in the North from day one, that there's a story to tell. It's harder. The segregation isn't mandated on the face of the law, but lots of people did lots of things intentionally to maintain separation. So Brown in the North is the run-up to this Detroit story.
Yeah.
And the book does spend a little bit of time, particularly in this Gary, Indiana case from the early 60s, talking about the life of Brown in the North that we no longer even remember or talk about.
Yeah, so let's go back for a second to Brown, and let's think about what we know in terms of just our classic version of Jim Crow, right? So we have a law, or we have an ordinance, or we have some sort of rule. It's written down, right? Everybody knows what it is. So we don't have to figure out whether the reason why the law was passed, because there was some sort of bad intent, or the intent was to segregate. We just assume that because the law says you can't integrate. You can't have children going to the same schools. They have to be separate. But what do you do in a situation where there's no state law that requires the students to be separately educated? But somehow or another, the schools are separate anyway, right? Does Brown speak to that situation? That's the central question that litigators and others had to deal with as the question became, well, does Brown apply above the Mason-Dixon line, right? What do we do in situations like Detroit or like in Denver or elsewhere where the schools are 99% African American and 97% white? How did they get that way? And if they are, does that violate the Constitution too, just as it does in Virginia and Mississippi and Alabama? Or does Brown have nothing to say about that, right? That's what you mean when you're talking about this idea of Brown going north. And so what's really interesting is the Supreme Court says we get Brown in 1954, and then we get another case called Brown 2 in 1955. And for the most part, the court kind of goes off and doesn't really talk that much about school segregation. But when it does, it's talking about it in the South. Meanwhile, there's lots of black parents in the North who are saying, wait a minute, wait a minute, wait a minute. We want our kids to go to desegregated schools too. And we think that there's segregation here too. And we think this violates the Equal Protection Clause too. And we think this violates Brown too. Will you please desegregate the schools? And the school authorities in the West and the North say, well, what are you talking about? Brown doesn't apply here. The schools are racially identifiable. That doesn't violate the Constitution. And yes, maybe the neighborhoods are racially identifiable, but we aren't responsible for the neighborhoods because we're school authorities. We've got nothing to do with what's going on in the neighborhoods or residential segregation. And so a number of lower court cases get brought, and they kind of go in different directions, but typically what the school authorities do in the mid to late 1960s is they say, we're not responsible. We didn't do it. There's no law that mandates it. Brown doesn't apply here. If there's anything going on here that's nefarious, it has to do with racially restrictive covenants or somebody else or something else or somewhere else, or look this way, right? And that's really the background to the case that I talk about in the containment.
Yeah, so let's get into the case. We can loop back around to some of these things. I mean, there are court decisions that say this is really a neighborhood school policy. The policy is to have schools centered in neighborhoods, and it's just a matter of happenstance. And that's just fine. That's good. Not much of an affirmative obligation on any officials to do anything about it. And the decisions, Professor Adams shows, the decisions do point in different directions. So a phrase that jumped out at me from the book is it's up for grabs for a while, and it's contested. That's important. So the story of Milliken is...
Just one thing on Up for Grabs, because there's a chapter called Up for Grabs, but I want you to think about, or think about the idea of, put yourself 50 years ago, We don't know what brown means, right? Part of what happens with Supreme Court cases is we don't know what they mean the day they come down, right? Supreme Court cases grow into themselves, and we, the people, decide what Supreme Court cases mean when we elect certain people, and judges go in particular directions with them. And so what a case really means isn't static, it develops over time. And so what's up for grabs is really this question of Brown. What's up for grabs is, what does Brown mean? How far does Brown extend? Does Brown just mean that we're talking about regional segregation in Mississippi, or does Brown apply across the United States? That's what's up for grabs.
Okay, so let's talk about the story. This is a very long and enormously complicated story. It's rendered beautifully, and it's highly readable, but doing it on stage is going to be a little tough, you know? It's a 400-page
See how well
book.
I do.
Yeah, well, I'm sure you'll do fabulously. So I think a good way into this is to take us to Detroit, say, between 1965 and 1968. A way into this is that there's a division in the African American community between advocates of what was known as community control, that African Americans should own and control and recruit for their schools and govern them, and integrationists, which included the NAACP and many white liberals. They're divided. They want the same thing, but they're divided on how to get it, right? And that actually is the genesis of the case in a way. So could you talk about that for just, a minute?
So if we go back and think about this question of up for grabs, right? The schools are segregated in Detroit, right? The mid-1960s, right? They are both segregated and they are unequal, right? So black children are going to vastly predominantly black schools, and they are not going to be allowed to be in white schools. And not only that, but the black schools are not well funded. They're not, in terms of the services and facilities and teachers teaching and certifications and all of that, they're not the same, right? So in effect, not only do we not have a Brown situation, we've got one that goes back to Plessy versus Ferguson, but even Plessy said separate and equal, right? Separate but equal, right? So the question is what to do about that, right? And so what Michael's getting at is there's different schools of thought in the black community as the best way to fight this, right? Everybody agrees the schools are separate. Everybody agrees in terms of the black community that they're unequal. The question is, what direction should we push politically now, right? And you've got a group of folks who are led by a really charismatic minister in Detroit who says, you know what, we don't trust white folks to run the schools, right? They got us here. Black children are being miseducated. We want to take the schools over. We want to run them. We want to control them. And we want what's called decentralization. And decentralization is, let's not have a top-down power structure in terms of how the schools are set up, but let's decentralize it and let basically parents get control over the schools. And that way we're going to have equality. We're going to have separate, but the children are actually going to be well educated. There's another group of folks, which I think is a larger group of folks, who say, wait a minute, what we've seen in the named plaintiff in our case, Berta Bradley, thinks that the best way to get an equal education for her child is to push for desegregation, because her observation is that when there are white folks in the schools, it's effectively green follows white. And so her desire, and it's sort of one of the things we talk about in the book, is sort of the different approaches that people had to trying to achieve equality, is let's push for the kind of desegregation they had in the South. And when that happens, my son will have access to all the same educational benefits that white folks have, right? And so this is part of what's happening politically at the time. Go ahead, Michael.
No, I just want to highlight green follows white was a saying that the money will follow the white kids, and many other benefits will follow too, like power sharing perhaps from integration. Why don't you finish your thought? Because I was going to jump to the context.
No, yeah, so if we're going to talk about the context, so this is what's brewing, right? People are unhappy. The other thing, the background politics of this are fascinating, though, because At the same time that you've got a black community that's deeply upset about the state of the schools and about the fact that their children are not getting a sufficient or even an adequate education, you've got some changes at the higher level with respect to the Detroit School Board, right? And for a long time, the Detroit School Board and the membership that ran the schools basically was running a separate and unequal school system. But beginning in the mid-1950s and going into the 1960s, you start having more liberal members of the Detroit School Board, and they actually care, right? They're coming into these positions, and they actually want to do something right, and they want to deal with some of these problems. And in particular, you've got the first black member of the Detroit School Board, Remus Robinson, who came on the board in 1955, and then the man who will become the president of the Detroit School Board, Abraham Zordling, who is very much an integrationist and very much a liberal. And so you've got these sort of currents happening sort of from below in terms of the student population, the parent population, and then you've got political things that are happening on top. Ultimately, because this is a long, complicated story, but we're gonna try to pull it together a little bit. The school board decides that it's going to have a limited integration plan. Just in the high schools, isn't going to affect that many students in Detroit, but for the first time ever, black students are going to go to white schools and vice versa. I don't think politically this was handled in the best possible way, and a lot of people felt like they were surprised. The reaction from the white community in Detroit is incredibly negative, and basically the board gets swarmed, and that's sort of when the state gets involved, and the state of Michigan ultimately passes a law that tells the school board, you may not integrate. You may not integrate. The Detroit NAACP says that feels kind of Southern, right? It feels like what they would do in the South. They would basically have a law that would say, you may not integrate, you must segregate. And so at that point, the NAACP gets involved and decides to sue. And that is the beginning. That's the background, but that is the beginning of the lawsuit that ends up in the United States Supreme Court in 1974 called Milliken versus Bradley.
Okay, so that gets us to the start of the case. Just to fill in a little bit, the board's integration plan is April 1970. It touches 11 of 22 high schools, and it influences, it affects 9,000 of 230,000 students.
So it's
modest.
It's very modest.
And all hell breaks loose. I mean, literally all hell breaks loose. Uprisings, new groups, walkouts, all white resistance to this very modest plan. And it happens fast. It's April for the plan, it's July for the state's law that says you can't do it, and it's August for the filing of the lawsuit.
That's correct.
It's 1970. Okay, now tell us about the lawyers. This is a last resort, as in Boston. We went to court because we didn't have anywhere else to go. You know, this is it. And I'm not sure that's actually correct, because maybe people could have done more politics before this, maybe not. We're up to the lawsuit. Tell us about the lawyers and their theory of the case, their strategy.
Just on the politics, so this is interesting, and I think it's a conversation worth having as we think about sort of things today and sort of how to go about trying to, you know, I often ask my students, what's your theory of social change? You know, how do things actually change? You know, one critique I would have of the board, even though I'm sort of politically in agreement with what they did, is that you would have needed significant amounts of community buy-in and advanced preparation to have this have any chance of not having the kind of backlash that occurred. The question is whether even if you had had that, you would have been able to have it happen. And I think there's part of the way that I think that maybe the head of the board is saying, no matter what I do, you know, they're not going to like it, so we're just going to do a jam down. Obviously, that's second guessing. You could second guess that determination. So it wasn't handled, I think, in the most politically adroit manner. Would it have changed things if it was? I think it would have taken a substantial amount of preparation, and even then, it's not clear to me that they would have been able to stay in their jobs, for instance. But keep going.
Okay, yeah, so we have these reform lawyers with the NAACP, and they file this lawsuit against the state and the school district in August 1970. The case comes on for trial fairly quickly. The trial starts in April of 1971. So it's a magnificent review of the trial strategy and how things played out in court. And why don't you start with Judge Stephen Roth?
So this book has really got a lot of characters. It's about characters. It's about how people behave under pressured conditions. It's about people's decision-making and who they are. It's about character to a certain extent. And so the judge is really at the core of this book in many ways, because he starts out being incredibly hostile to the plaintiff's case, right? He's a Hungarian immigrant, comes to this country, sailing in steerage, grows up in Flint, working class area, is part of the conservative wing of the Democratic Party, and really basically thinks that this lawsuit is complete BS. Get out of my courtroom, I've never heard of such a thing. And the reason he's saying that, again, think back to Up for Grabs. He's like, Brown, equal protection, that happens in the South, right? That's the thing. That happened in the South. Yeah, it's illegal. Yeah, it violates the Constitution. But we're in Detroit, Michigan. That doesn't happen here. That's his first reaction. That's why this is up for grabs, right? And so he's someone who changes over the course of this trial. And just to sort of remember now, well, why are we in court? Because the state passed a law that says that you can't have your integration plan. It gets more complicated, and we won't have to get into all of the nitty-gritty, but suffice it to say the case ends up becoming much larger than whether that one single state law violated the Constitution. Ultimately, what the lawyers do, the change lawyers, the reform lawyers do, is they say, well, Michigan's a big school district, and it's separate and unequal. And we want to be able to prove, if we just challenge this law, who knows what kind of remedy we're going to get. And actually, the deep-seated nature and what's really happening in Detroit, why did it happen? How did it happen? Why are the schools segregated in the first place? So even though the board, remember, had been trying to do the right thing, again, they were doing that against the background of many, many years of intentionally segregating the schools. And so now the lawyers say, we want to prove it all. We want to understand the entire way that this happened. We want to know exactly, how the schools became so segregated. And they understood what was happening in the lower courts. They understood that in previous cases, that basically the school authorities had said, well, we're not responsible for the residential segregation. We're not responsible. It's neighborhood schools, like we were talking about 15 minutes ago. So they said, you know what? We're going to decide this, and we're going to put on this incredible trial. It's going to be 41 days, and we're going to basically have a housing case inside of a school case. And what we're going to do with the housing case is take away the ability of the school authorities to say, you know what, it's got nothing to do with us. It's just, we're going to take away the ability for them to say they acted in a racially neutral fashion. And the way we're going to take that away is we're going to show that it was race discrimination all the way down. Right? And so we can talk about some of those mechanisms, but the key thing to understand about the trial is that it's not just schools, it's schools and housing.
Yeah, and much of the book, there's a chapter, but the nexus between and the interactions between and the synergistic relationship between housing segregation and school segregation. So the lawyers put on really sort of two cases. The first part of it was a housing case about how intentional actions of many, many public and private actors create housing segregation. And then they sought to prove that prior to the liberals on the board itself did lots of things: school construction, feeder patterns, expanding
school zoning,
to intentionally segregate the schools.
Yeah,
that there was as if there was a law.
Yeah, that's the thing. And so just so we're together, because you might be thinking, well, what are they talking about, right? The school portion of the case is, what are the different things the responsible authorities with the discretion to be able to take actions actually did that intentionally segregated the schools? Remember we talked about this idea of like, well, there's a law in Mississippi. We have to show intent. But in the North, you've got to be able to connect the fact that the schools are racially separate with an intentional act of a responsible state authority. And that's the difficulty. So it's having to put together all these things like a tapestry, right? Having to show that, you know, we let white students transfer out of black schools, that we decided to construct black schools in the heart of black neighborhoods, not on the edges where, you know, students could attend the same schools. We have to show that you know, when you went to a certain junior high school, then you were going to be fed into a certain senior high school to make sure that you weren't going to see and you weren't going to come into contact with any other white students, this kind of thing. All those pieces had to be put together like a jigsaw puzzle.
Okay, so we can fast forward a little. We've proven discrimination. The judge is swayed and he becomes won over. Just two things now. So tell the students about the best witness in the courtroom, because I think this is quite entertaining and powerful. And then we have liability. We want to desegregate the Detroit schools, but 60% of the students in the Detroit schools are black already, and that number is going to go up. So the trial wins him over, but then he has this problem. What do we do?
So when we think about, you know, sort of big constitutional litigation, oftentimes you have two different pieces of your case. You have the liability portion of the case, and this is mirrored in Brown 1 and Brown 2, where you're basically trying to show that there was a constitutional violation. So whatever it is you got to do, you're going to have to show that, in fact, the defendants violated the Constitution. But that's just the first part. The second part is trying to show, well, now what's the appropriate remedy for the constitutional violation, right? And so this case really proceeds in that way. Well, first you've got the liability finding, and then you've got the remedial holding. On the most important witness, so, you know, one of the things I think the lawyers did well was there were these big maps that the judge would kind of sit back and sort of look over his shoulder and look at. What were the maps of? There were 4 separate maps. Of course, in this country, we do a census every 10 years. So we had Detroit census data going back from 1940, 1950, 1960, and fresh census data from 1970. And there were these huge maps, and what they showed was the containment. They showed how African Americans were basically grouped in small portions in the center city. They moved out a little bit, and then out a little bit more by 1970. And so the judge kept looking at the maps. And the reason why it was so important was because I think the judge came into the case thinking that people just wanted to live together. But he didn't really think that there might be reasons why they had to live where they had to live, and I think the maps helped him see that.
Yeah, I mean, imagine it's 10 feet by 20 feet. It's a series of plastic relief maps, so there were foldovers that came down, and the judge just had to look at that throughout 41 days of trial, and on this account, it was a powerful graphic illustration of the containment. So let's get to the remedy. He finds that the school district did a lot of things to intentionally segregate the schools. He finds that the state passed a law to eliminate a modest desegregation plan. He finds that the state school construction policies contributed to this segregation. But he has a problem, and maybe you could talk a little bit about the judge's problem and a lawyer in the case we haven't mentioned yet, Alexander Ritchie.
Yeah.
This is a fascinating part of this.
Yeah, this is something I certainly
about whites and class, right?
Yeah. So he's got a problem. He's got this constitutional violation. We've got Browns in the north, right? Browns in the house. What do we do about it? You know, Detroit is becoming increasingly white every passing year.
Black, you mean? Black.
Excuse me, black every passing year, particularly after 1967 and the civil unrest there. And one of the things the judge doesn't want to do is say we're going to have a Detroit-only desegregation order, and that may actually create an additional incentive for whites to leave to go to the suburbs. This matters because at this point in time, it's not as if African Americans can go to the suburbs, right? The suburbs are largely closed to them because there's 2 basically racially separate housing markets. And so the judge does not want to do anything to make that worse and to create an incentive for folks to leave. But most importantly, we're back to the question of what does Brown mean? We're back to the question we talked about earlier in terms of what is the scope of Brown versus Board of Education, right? What does it mean to say we're going to have meaningful desegregation? Right? Does Brown just sort of say, well, we have to stop violating the Constitution, and that's enough? Or was Brown really about saying that, we have the capacity to be one nation rather than two, and to try to create that possibility? And I think the judge was reading Brown, the judge was reading Brown too, and the judge was reading all the Supreme Court cases that were available to him at the time, and he said, you know what? I think the Supreme Court has said that Brown requires that we have meaningful desegregation in the city of Detroit, not desegregation theater. And in order to have meaningful desegregation, we have to involve the suburban school districts. And so what he decides to do is to create a very large metropolitan school desegregation plan, and it would have been the largest metropolitan school desegregation plan in the history of the United States. Would have affected around 800,000 students, and would have affected about 50 separate school districts. Now you might think, well, what would make him think he would have the power to do that? And there's a couple of answers here. Number one, the state of Michigan was found liable for violating the Constitution. And under state law in Michigan, education is a state function. Every single school district in the state of Michigan is a state agency. So even though it's a suburban school district, it is a state agency. And under state law, Michigan can combine school districts. It can take them apart. All of that power lies within the state, not independently within the individual school districts. So what the judge basically thought was, well, there's a finding of liability against the state of Michigan and the state authorities, and because that finding of liability goes to the state authorities, then they can be charged with having to deal with this problem. It's a statewide or a regional problem, and consequently, I have the authority to do this. The other reason why the judge thought he had this authority is because time has marched on and there's new Supreme Court cases, right? And in 1971, the Supreme Court decided a case called Swan, and it gave broad authority to federal district courts to be able to remedy Brown violations, including the use of busing. And so this is fresh off the presses, came down in 1971, really talked about the ability of courts to be able to do this. So the lower court judge looks at Swan, looks at the Supreme Court authority, reads Brown too, and says, you know what, I can do this because the state's in the dock.
Okay, so could you talk about the role of the white parent groups who have intervened to defend, to resist the plaintiffs, but they have this lawyer who starts talking about, if you're going to do this, you have to include the suburbs.
One more thing. How did the judge get this in his head, right? He's reading all the cases, but the way that he gets this in his head the first time around is from this group called the Citizens Committee for Better Education. And it's that group that is a white group that had intervened in the litigation. And they were the ones who basically sort of put this metropolitan idea in the judge's mind, sort of first of all. And their position is, and these are a group of white Detroiters who are living in northern Detroit, and their idea was, listen, we don't really want a Detroit-only school desegregation order. It's not really in our best interest to have that. Right? We think the value of our housing is going to go down once this becomes the rule, if it's the rule in the city of Detroit. So really, this ought to be a metropolitan problem. We, the white residents of Detroit, shouldn't be the ones who are stuck having to, you can't balance the books of the constitutional violation on us.
Right, okay, so he does this. He starts to do it. He starts to bring in the suburbs, starts to plan an integration plan. There's a group that starts to plan this, but obviously the state defendants and the school board appeal. They lose on appeal. The appellate court upholds Judge Roth twice. And then we get to, and then we're gonna wrap up here. The Supreme Court gets the case and decides it in 1974. What does the U.S. Supreme Court do with the case? And then we'll talk a little bit about consequences and what might be done now, and we'll open it up.
Yeah, so, again, if we think, going back to sort of this idea of up for grabs, it's so interesting that the Sixth Circuit Court of Appeals, which is the intermediate appellate court between the trial court level in the federal system and the Supreme Court, upheld the judge on this question of, the metropolitan remedy. And so this really is a moment where it could go either way. Like, what does Brown mean? Like, we're creating this as we're going along. And we get to the Supreme Court, and by then, the court is different now, right? So when Brown came down, it was the Warren Court. It was a more liberal court. By the time we get to the Supreme Court in 1974, it's a more conservative court, and Nixon has put 4 appointees on the court. And the Supreme Court basically says that that remedy is not consistent with the constitutional violation, right? That the remedy itself is too big, it's too large. It's pulling in all of these suburban school districts, but there's no evidence that any one of those individual school districts actually created segregation or discriminated in the city of Detroit. So the idea, or the rule that we get out of Milliken versus Bradley is, if there's a constitutional violation and it's in the city of Detroit, the remedy has to be there too, right? You can't have the remedy happening in other places. It's got to be in the city of Detroit and Detroit alone.
Right, so this basically shuts down this possibility, and Professor Adams has said this is the end of the Brown era. If Brown stood for actual integration and going to school together across the lines of race and class, most would see this as a case that killed that made that impossible. So maybe talk a little bit about the consequences of this decision, maybe what a decision the other way might have meant, and maybe we could wrap up with what we might do and think, what are the implications now, right?
So, up for grabs, right? So one of the first things to think about is the idea of limitations of Brown and giving Brown a narrower reading of talking about it having to be like right in this district. But Brown itself never talked about that. The promise of Brown, the possibility of Brown, that it could be used in a way to sort of try to bring us together more as a nation and support metropolitan school remedies, that idea kind of goes out with Milliken versus Bradley. In terms of the federal side, I mean, there's litigation going on in states, and we can talk more about that. But this sort of grand idea that you could use Brown as a way to sort of support metropolitan school desegregation, that really ends in 1974. There have been a bunch of copycat cases that were being brought at the same time, and they kind of, don't really go anywhere after that. Michael, you asked about sort of what would have been different, or what are our possibilities now? Both.
The counterfactual, and this is controversial, like I kind of think a decision the other way wouldn't have been enforceable. It would have been violent, and maybe obviously a decision the other way would have been better, because we don't know what the long-term meaning of that would have been. And then what do we do with this now? The racial isolation and the concentration of poverty in ghetto schools has gotten much worse over the last 30 years. These are schools that are overwhelmingly composed of members of racial minority groups and overwhelmingly poor. One scholar put it this way: nothing much grows in a desert. The problem, and obviously we've had a lot of diffusion of people into suburbs, and we have more integration in certain senses, but these ghetto schools, they don't work. So what do we do, and how do we think about this now?
So just on the counterfactual piece, I mean, I think part of it goes back to the question we were asking before about what's your theory of social change? And that's a conversation you and I could have for a long time, right? I guess my theory of social change is that we tend to run in cycles in the United States. And so to the extent that we're going to run in cycles, you always want to go as far as you possibly can, recognizing that in fact you're likely to be pushed back, but that as you move forward, it's a sort of slow incremental steps. And so, in terms of a counterfactual, I can't sit here and tell you I know exactly what would have happened if the court had gone the other way. One thing I can certainly say, though, is the fact that there's such a poor understanding of Northern Jim Crow. I mean, there's a lot of problems that Milliken created, but one of them is just the fact that we don't understand our history very well. Some of the things we're fighting about right now have to do with our history and sort of whose history, but it's all American history. And if the story that I tell in this book and that we've been talking about for the past half hour or so if you were to just pick up the Milliken case and read it right now, you wouldn't know any of that, right? That's one of the reasons why I got so excited about this project, is that if you just go to the case and you read it, what I just said won't make any sense. There's no connection between the two. And so not only do I disagree with the ruling that the court had with respect to the remedial portion of the case, the court gives us a really ahistorical, incorrect vision of history, because the history was coming out in Judge Roth's courtroom, and it was the court's choice to ignore that and to, in some instances, actually create a sort of counter-narrative that's not correct. So yeah, I think there was going to be backlash either way. That also is an argument that kind of falls a little bit flat for me, because we had that in the South, right? We had backlash in the South, and we had significant moves forward. The empirical evidence in terms of sort of, African-American students sort of closing the achievement gap with white students most successfully during the periods of time when desegregation was most strongly enforced. So yeah, there's going to be backlash. There's always going to be backlash. But I think we move forward. We continue to move forward. I think the last part of what you were asking about was sort of for today, and I think, a good chunk of this book has to do with democracy and citizenship, and sort of the integrationists and the folks who were really trying to build cohesion across lines. That's one of the other stories, the pieces of this book has to do with the fact that there were parents on the ground, and this is not particularly widely known, who were trying to organize across jurisdiction and across race to sort of make this work. And so that kind of organizing needs to continue, and there are organizations through which it is.
Yeah, thank you. I'm going to open it up, right? So we have a microphone here. I have a microphone in my hand. See if I can avoid the feedback. I don't know. I think we could do a round of applause right now. Thank you so much.
Thank you.
That was really spectacular, and I highly recommend the book. And if you're a student and you want a copy, you can contact me, and I'll see what I can do. Questions, comments? Anyone? Okay, Thomas? Let's try to keep it a minute or two each when we make a comment or ask a question for our guest.
Hi, Thomas.
Hello. So you mentioned that Milliken v. Bradley led to this sort of, that the remedy of a constitutional violation would only be in a specific district. Even if it's could be resolved through a state issue, it had to be within the realm of the district that it is happening in, correct?
Yeah.
So we understand now that there is this broader issue now where segregation is contained into these inner cities. And with Bradley being, and not really more of, I don't know how to put it, it's more like the unenforcement of Brown, I guess, is the term that I would go with. How could we potentially aid these? Because with the schooling performance, especially in these areas where the taxpayer dollars that go into these districts are much worse off because there's not as much funding, the people who get into the teaching jobs aren't as great, stuff like that. So how would we potentially move on from that and try to make these schools better with the absence of state enforcement?
So
Thank you.
what has happened since Milliken is there's been a lot of litigation. So there's, the federal government, we have a constitution, a federal constitution. There's also state constitutions. And some state constitutions say that students have to have an adequate education, and then some courts have interpreted the word adequate in the state constitution to mean that it has to be an integrated education, right? And it's also, some of these courts have also interpreted that language to mean that it has to be relatively equal in terms of funding. So there's been a lot of litigation around state funding. One of the other cases I mentioned in the book that we didn't talk about is the court also said that there's not really a federal right to education, and so even if you're sitting in a district where you're getting 1/3 of the amount of school funding as a district that's right next door that's getting so much more, you still don't have a federal constitutional right to complain. So the answer is it's happening piecemeal. It's happening in terms of state constitutional litigation. Millikan was a big deal. You know, having said that, there's still, we've got a lot of movements towards school choice. Magnet schools can be really, really good, right? So there's stuff that's happening out there, and there are new groups that are growing up, but this was a missed opportunity.
Okay, thank you. Questions, comments? Yes. I'll be right back.
Hi, I guess it's just a quick question. With Detroit, because the ruling did apply to Detroit that there had to be desegregation, what happened over time, what the judge kind of predicted and why he proposed the metropolitan remedy, that it ended up being that?
So it goes back down to the lower courts. The Judge Roth, who had presided, had died of a heart attack. New judge is appointed. There's a Detroit-only desegregation remedy. Detroit continues to change in terms of its racial makeup. I think reaching at like 92, 93% African American at one point, although that's starting to change. The school system in Detroit has gone through some significant difficulties, shall we say. There's another case that I talk about towards the end of the book, where there was actually a group of lawyers who were saying that Detroit children were being deprived of their right to literacy, which was a new and very difficult claim to prove. That children were being so miseducated that it was basically a travesty of education to require them to be in schools where there was no education going on. Things have gotten better. That case was brought in 2016. But some of the things that I think Judge Roth was concerned about came to pass.
Yeah, and noting that the case took its toll on this man. Clearly, he died at 66. Yeah. Okay, over here.
You mentioned like about state constitutions, but there's also city constitutions, which means. Sorry.
I'm coming down.
I'm sorry. I can speak.
Go ahead.
So, with city constitutions, it's also like up to the city to determine how the school system works in that particular city, and then with some cities like we obviously know that some cities could have a better education system than others, which might make an adequate amount of education in certain cities more difficult.
Well, so typically cities won't have a constitution. It's usually a state that has a constitution, right? The power that cities enjoy typically is taken from the state. The cities are talked about as being political subdivisions of the state. You're right, though, that different cities have vastly different educational systems. The question becomes why that is. Why is the funding different? And some of this goes to just how the state has made determinations as to who's going to get the money and how. But the idea that you could group a certain number of school districts together and have them be part of the same metropolitan remedy as a matter of federal constitutional law, that's what ends with Millikan versus Bradley. Unless you can show that each and every suburban school district that you want to have in that remedy actually created a constitutional violation. So you're not wrong in the sense that different cities have vastly different educational systems, but ultimately the state is the one that has the power, and the cities sort of get their power from the state. Yes and no, right? Because the United States Constitution, the Supreme Court interprets the scope of the United States Constitution, and it can say that there's no federal right to X. But that doesn't mean that a state couldn't say that, in fact, you have a right to something, then we're going to provide it, right? So that's sort of an interesting part of our federalist system, which is, you know, the states can't violate federal law, but the states could actually the states could decide to provide more protection. The states could decide to provide more money. The states could decide to provide more education. The states could say, we want to have a 200-day school year as opposed to 180 days, right? The states are certainly free to do that.
Okay, I want to ask, anybody else? I wanted to ask you about the legal theory, the legal frame. I mean, I understand why it had to work out, that you had to show an intentional action that causes segregation. That's what the legal doctrine was. There were alternative arguments that the state's responsible, period, right? I mean, the state should have an affirmative obligation to care, to do something about it. What would that be grounded in? Equal educational opportunity? Segregation harms everything? I mean, it's really... Go ahead.
So Michael, you've raised something really interesting that we talk about in the constitutional law class, which is sort of what kind of constitution do we have in the United States? And we often talk about the idea that the United States is the Constitution is one of a negative charter, which is to say that it prohibits the government from doing certain things to individuals. That's really what the Bill of Rights guarantees are. It constrains government, right? And it allocates governmental power across 3 branches of government. What our Constitution doesn't do, which is different from many other kinds of constitutions across the country, across the world, is it's not a charter of positive rights. There's no provision in our Constitution that says that you have a right to education. You have a right to minimum adequate health care. You have a right to minimum adequate food and nutrition, all of that. That's not the way our Constitution was written, and that's not the theory of our Constitution. So then you start asking the question, well, what do you do? And that's part of one of the reasons why I think Brown and Millikan are so interesting, and there's been some writing about this. The distinction, what kind of right is the right that Brown recognized, right? Is it a right to be free from state-imposed segregation, or is it an affirmative right to some kind of minimum educational entitlement? And you could sort of talk about it in those two. It's sort of like you could sing a song in 2 different keys, right? It's the same song, but it's in different keys, right? And sort of one way to think about Brown is that kind of an affirmative right to some sort of entitlement of something, right? Maybe an entitlement to an integrated education, maybe an entitlement to equal educational opportunity. And Millikan would have taken us a little bit of the way towards that vision of Brown, a more substantive vision of Brown. And I think what the court does in Millikan and other kinds of cases is say, no, that's not what the Equal Protection Clause is about. That's not what Brown is about. It's about a right to be free from state-imposed racial classification schemes. That is how the current Supreme Court reads the Equal Protection Clause. It's a right to be free from that. It is not an affirmative right to anything.
Right, so much so that when school districts occasionally take the initiative and try to engage in integration, classifying by race to integrate, you talk at various points about parents involved in community schools in 2007, where the court basically said, no, you can't classify the individual student at all for that purpose. You might take race into account in terms of neighborhoods and socioeconomic status might come in, but you can't use the racial classification for a benign purpose. And then we have the recent affirmative action case, which does basically the same thing. So, color blindness.
Right. I mean, so then sometimes folks will ask, well, can anything be done? And that's part of some of the questions we're getting. And I think the answer is, it's important not to overread the Supreme Court cases as well, right? The point you just made about economic is really, really important, right? Which is to say, yeah, the Supreme Court said you can't use race, right, affirmatively. You cannot use racial classifications. But the court has not yet said that you couldn't say, well, listen, we want to have economic integration. Or we want to use what's called a racially neutral mechanism to achieve race diversity. That's still constitutional. So for instance, you could say we want to try to use certain zip codes, for instance, or something along those lines, different kinds of geographic, with an eye towards creating more diversity. That's still constitutional, although I think not for long.
Okay, thank you. I think this is a good place to end. Thank you all for coming. Thanks for bringing your class. And we have the clue sign-in sheets. If any students need clue credits, they're here. Professor Flanagan has them. There's a great reception upstairs. Really, there'll be plenty of food for everyone. Please join us. We can continue the conversation upstairs now, and please join us again on October 29th. One last time, this is a wonderful book and a wonderful scholar. She's here, pretty much pro bono, which means she's, just, could you mind? Like, she can get a $5,000 fee. I didn't offer her $5,000 to come to the College of Staten Island. I offered her a little bit less, right?
It's my pleasure to be here.
Yeah, it's really great. Thank you so much, and thank you for a wonderful conversation.
Thank you.
See you upstairs.